Aditya, you are there?
Yes, sir. Yes, sir.
Okay, okay.
Hello, sir. Can I start?
Dumane sir?
Yes. Yeah. Okay.
So should we start?
Yes, you should. Yes.
Okay, sir. Okay. Rupali ma'am, over to you.
Okay. Thanks, Gunjan ma'am. Good afternoon, all. I, Professor R.S. Sawan, from Computer Engineering Department of Jagdamba College of Engineering, welcomes you all for the expert talk on the importance of intellectual property by Dr. W.M. Dhumane. Is a renowned personality who having a contribution as a IPR chair in Maharashtra National Law University, Mumbai. Sir will provide details regarding what is intellectual property along with the importance of IPR. It is a very good opportunity for all of us to grab the knowledge from such an experienced personality. So without taking much of time, now I request to Professor A.A. Golpekar, please give brief introduction of today's guest, Dr. W.M. Dhumane. Golpekar sir, please proceed.
Thank you, ma'am, for giving me the chance to introduce such an eminent personality. So, Dr. W.M. Dhumane, DPIIT IPR Chair Professor from MNLLU, Mumbai. W.M. Dhumane, sir, is MSc in Chemistry and PhD in Chemistry from Nagpur University and LLB from Mumbai University. Before joining the MNLU Mumbai, as an IPR Chair Professor, Dr. Dhumane was associated with Patent Office, Intellectual Property Office IPO, Ministry of Commerce and Industry, Government of India for 20 years. He joined Patent Office in August 2000 as a Deputy Controller of Patents and Design through UPSC and function as a controller of patents and design as a statutory authority for grant refusal of patents under Patents Act, and subsequently ascended to become Senior Joint Controller of Patents and Designs, the highest post in Indian Patent Office, and retired on 31st May 2012. He functioned as Head of Patent Officer at Chennai and Mumbai, and also as a Head of the Office of Controller General of Patents and Designs and Trademarks, Mumbai. Prior to joining the Patent Office, Dr. Dhumane had worked as a mineralogist in Mineral Exploration Corporation Limited, Nagpur, a Government of India enterprise up to July 2000. He was also a member of Subcommittee of Indian Standards Institution on Minerals, member of Board of Studies in Chemistry, Nagpur University, and member of the Committee of Lakshminarayan Institute of Technology, LIT Nagpur. After his retirement from Intellectual Property Office, recognizing his valuable contribution for bringing in development and reforms in Intellectual Property Office. He was appointed as an IPR consultant by IIT in IPO from 1st June 2012, and he continued as a consultant in IPO Mumbai till his joining MLU Mumbai on 10th June 2020. Thank you, sir. Thank you, ma'am.
Thank you, sir. Now I request to Dr. Dhumane sir, please continue the session. And if anyone having any query or doubt within the session, then you can post your messages. And after the completion of session, students or any faculty members can ask the query directly to the sir. So, sir, now I request please continue the session.
Okay, thank you very much for the management of Diploma in Electrical Engineering and dear participants who are attending. I hope they are engineering students, professors. Somebody can reply to me.
Yes, yes.
Students and professors.
We listen you, sir.
Okay. You can listen to me.
Yes, yes, sir. Yes, yes.
Okay, this option is coming over here. Okay, you can listen to me. No issue. Now you can see my presentation also.
Yes, sir.
One second. Just let me see. Okay. Now you can see my presentation also. Hello.
Yes,
Yes,
sir.
sir. Yes, sir.
So, thank you, Gunjan, and thank you, the management of MNF also, for bringing us together on this occasion. So, this is my first experience with any institute in Yavatmal to interact, and it has taken so many years. Although I belong to Yavatmal districts, and I graduated from Amritsar College, Yavatmal, way back in 1972. Thereafter, I moved to Nagpur and thereafter. So it is a great pleasure to speak before the participants from Yavatmal College, first of all. And then I will try to explain to you what are the IPRs in brief and the introduction and importance, and then just quickly switch over to patent system in India. I hope you students and professors are more interested in knowing about the patent system in India, right? That's correct. Is okay? You is okay?
Yes, sir.
Now, when we talk about intellectual property rights, there are three words, that is intellectual property and rights. So these rights are granted by statute under the Government of India for the property, like any other property, like your house property or any factory or other things. But this right is different in that it is regarding intellectual property, intellectual creations which are made by human mind, and human mind is bestowed with a great capacity to generate ideas of various types on various matters when they move every day or work in the lab or like that. Anywhere idea can be generated in the human mind. This idea can result into so many manifestations, like, and that depends on creativity of the person's and innovative nature. So there is no limit to idea in manifestations, but ideas do not get protection as such. So what you create through the intellectual capacity and ingenuity, and how does it manifest, then that manifestation is protected as intellectual property rights by the government. Now, this intellectual property which is created through the manifestation of idea is of two types. First, the industrial property, and other is copyright. Why copyright is classed separately? Because there is no bearing on industrial property per se, or copyright, and other IPRs, that is patent, design, trademark, GI. These are four main IPRs, and other minor IPRs are semi-conductor layout and plant variety protection issue in the system. They are not per se the IPR plant variety, but it protects the farmers' rights on new plant varieties, and semiconductor layout protects the integrated circuits. Like that. So major IPRs, industrial properties, patent, design, trademark, and GI. And let us see scope for this. Now, when we say that intellectual property rights comprises of patent, industrial designs, trademark, copyright, GI. So you'll be interested in knowing whether there is any overlapping between these. But let me make it clear that there is no overlapping between these intellectual property rights, what we call patent, designs, trademark, copyright, and GI. So patents are granted for an invention which is often a technical solution to a technical problem. Then, so it is given for invention. Industrial designs is given for external features of an article. It can be new shape, pattern, ornamentation, configuration, etc. as applied on the article, and which appears to eye that it is good and new, etc. And then what is the decision-making process in design? That is, how does it appeal to eye and is just solely buyer? So if your eye says that this design is new and it is attractive, then it is industrial design. So it is external features only. Third is trademark, that is distinctive symbols. Distinctive symbols, and it can be word, name, logo, label, etc., which is applied on an article of manufacture or service to indicate the origin. So trademark is for distinctive symbol, and the copyright is given for artistic creations. This comes into existence as soon as the work is created. It is a group of rights per se. On the other hand, geographical indication, what we call bhaugolik chinna, it is given for agricultural, natural, which have special quality or reproduction based on the unique characteristics of that area. The oranges from Nagpur and around that area are famous and unique products based on the quality of oranges. So, patent, design, trademark, copyright, and GI, there is nothing common as regards scope and nature of rights. And these are given for different things, so it is not good and it's not desirable to say that Tirupati that has been patented or not. GI. Design, trademark, copyright, GI are aspects of product, and there is no overlapping among different IPRs as regards scope. However, all these ideas over the market, it may be governed by the new technology, maybe for whether it is inside, outside, or some mechanism. Design as how does it look, a trademark, name of the company, manufacturing, maybe prestige, or etc. Complex or caution, which is given completely for the book. Now,
Yes, sir.
I just want you to do. We will see for each individual rights in detail extent from designs. So, industrial design is second IPR. And what is design? When you are engineering students, that is because industrial designs, although it is called industrial, it is purpose. Design is applied on the article, which is by eyes. So it is external features what we apply on the article. For example, a toy, watch, cooker, etc., pen. You take every article, and there is new design can be made daily. So new shape, configuration, ornamental, etc., combination, everything which is applied new on the article. Carbon is two dimension. For design applied, external designs is given for registration. Was seat, etc. By any industrial process, whether manual, mechanical, or chemical. The idea is that there should be regular production of that. So, howsoever interesting design of makeup may be, it cannot be done by industrial process. So, the things which are not created by industrial process, industrial scale, those do not qualify for designs. And the testing is that design in the finished article, when the article comes before you with that new design, is just by guy. So there is no other compared with update designs. If it is new from the update designs, then only registration is given. Certain designs are not registrable. That is, the design which is not new or original, which is already disclosed to public, that is already in public domain. This is not significantly distinguishable from known designs, and when it contains scandalous or obscene matters. So these designs are not registrable. So further, articles which are not registered as designs are calendar, certificates, forms, greeting cards, display maps, building plans, data tables, tokens, stamps, release symbols, flags, emblems, or sign of any country. Layout designs of interior circuits, mere working alteration, and mere changes in size are not registrable as designs. I request when my voice is not clear, let me know. Somebody should let me know, okay?
Yes, sir.
Now clear now? Okay, no problem. So let me know when there is no clear clarity, the sound is there. So another aspect of industrial design is that design does not include any principal mode of construction or article or mere mechanical device. Is very important to know, because your toy may contain the test electronic circuit, etc. which makes it jump or run or other parameters have been applied, but they amount to functional matters and they are not registered as design. And any trademark or property mark or artistic work applied already on the article, they have to be disclaimed because they are not registered as design. So design is the plain visual aspect of the article, right? So design right has to be plain in an application or new design. We made to design office in patent office at all court location, depending on jurisdiction. Calcutta office examines these applications and give you design registration. If there is no objection, then within 6 months from the filing of application, which is very simple and very small fees up to there, not much. So after getting design right, it's valid for 10 years from filing. It can be extended further by 5 more years. And you can now understand that designs are of great commercial value because when you enter the market and for the shop for that matter, purchase any article, you will be attracted to a new design available on that article first, and then you bother as to from where it is coming and what is technology. If it is not suitable, technology is not appropriate, then you will switch out to next attractive design of the same article. The designs of great commercial value because they add a value to product, makes the product look attractive, and particularly for MSMEs and startups. Design registration is a guarantee for business success because they create small things and innovative designs ensures that they are selling well and they can get success. So it is rightly said that when companies are competing at equal price and functionality, design is the only differential that matters. So you can find that there is design in all the aspects of life every day. There are so many designs like from clock to car, chappal to bike. Further aspect of design is that state of article is also registered as designs. So as we know, one article and one registration of design, but here exception is when it is presented as a set of articles. Clothes, for example, furniture set or tea set, etc. Because they are of same general character, same design is applied, and they are used together. Design, there are different classes in which design is applied. So if design is in particular class and not registered in another class, same design can be applied according to that class. So it is class-based registration. However, the size of same article, different sizes of same article do not qualify as a set, knife set, pen set, chair set, etc. As I said, industrial designs help small business owners or startups, right? So the small innovative articles that you are seeing here are special product for small entities. There is no limit to how people will register or apply for the foreign examples of innovative designs. So the warm loaves of bread shape is given to the babies here. Then cozy bed was designed for cat. The bed was attached with this space for pets or cactus shaped chair or horse presented on the right table in this format. So there is no limit literally for registered design. You can think of any new design or any article. And if registrable, as we have said, you can apply for registered designs and get the benefit of design because violation of any design will attract punishment or action by the design office or by court. So you have to give representations in your applications of your designs. It should not contain written material. Photographs should be clear, like this. This you have to submit as a specimen sheet for representation. This is for chair with different photographs of different angles, and you have to say that novelty resides in the shape. Where does the novelty of design reside? Because that's the important part. Then you are not claiming any mechanical or any functioning part. that also you have to give statement. And you are not also claiming any trademark or copyright material. That disclaimer you have to give two disclaimers. That is no registration for trademark, etc., and no registration for copyright material, etc., and no registration for function part, along with the statement on novelty, completes the repeat. So this was briefly for designs. Now we move to trademark. So trademark is what? Trademark every day we see the in life that Tata, Bata, Bima, or Reliance, Big Bazaar, all everything you look at when you come out of the house or even in the house, all articles you are using are having some trademarks. A trademark can be the test of trademark must be represented graphically as a distinctive visual symbol. So it should be visually seen, and it should be able to capable of distinguishing goods and services of one person on the top of that. Yes. Anything? Hello?
You may continue, sir.
Okay. So, trademark may be word, name, logo, label, numerals, or combination of colors. And goods or services can be distinguished by trademarks. And goods or services of one person from those of others. They are distinguished the basic function of the trademarks. And trademark must be applied on the article or service. It indicates the origin and from where this trademark goods are coming, or from where the service is coming, and it can include shape of goods and packaging also. Service mark can include banking, education, finance, insurance, etc. Trademark is valid for TDS like design, but trademark is valid perpetually, not like 15 years maximum for design, is perpetually, provided you renew it every 10 years. So, you might have read the phrase that what is in name coined by Shakespeare. So this doesn't hold true for trademark because there is much value and money in the trademark, because trademark is the right which can be sold, and it can be sold for millions of dollars also. Like Coca-Cola, a very famous trademark, you can verify from the literature. The value, market value of any good trademark is beyond your thinking, millions of dollars. Okay. Trademark can be word. I was say already. Pepsi, Coca-Cola, etc. Example. Names can be like Larsen Tobacco. Surname, Tata Bata, or letters, numerals. These are registrable provided they are distinctive in nature. Means they have acquired their name and fame by virtue of their continuous use. Otherwise, surnames are not registrable as trademark normally. They can be symbols like Tata, SBI, Adidas. They can be device like shown here, Apple or Amulgar, the device marks, because Amulgar as a whole is trademark. Color scheme for Pizza Hut, Domino's, packaging, that Cadbury's packaging, shape of foods, Coca-Cola bottle, or sound. Coca-Cola bottle, by virtue of its specific shape, is registrable as a trademark. Sound, for example, MGM Lawrence marking, trademark. So that sound which is coming out when MGM logo comes, that is registered sound mark. We have started sound mark registry in India from 90 onwards by the amendments of trademark at 90. So it can be combination of all these also. Not necessarily one, it can be color combination and symbol, etc. Like group bond, red label T, red label, as well as the tracing of that. Thus, the whole thing is registered as a trademark. So trademark can be registered or unregistered. That's a very peculiar thing. As I told you, that design has to be registered. Patent has to be registered with the patent office or design office respectively, but trademark may not be registered. prior to anybody's use and application later on, then your right over trademark will be there. Even if not registered, so that unregistered trademark has to be approved by you. That it is your trademark, you have to prove it. For registered trademark, Sumoto Registration Authority is established. But prior user consent is superior to prior registration for trademark. Trademark should not be prohibited by law. That is emblem of India. Our trademark should not contain obscene matters. Trademark should show the examples which we read in newspaper. That somebody has applied such obscene matters regarding God is God or something on the trademark. So, trademark should not have religious or sacred feelings of any citizen from any religion. Trademark should be distinctive. Our best trademark is a calling word form dictionary, which is not dictionary word itself. It's prepared like that. For example, Kodak. Kodak is not a dictionary word, but it's a very popular trademark like this. The moment you use any word which is describing the goods itself, it is not registrable. Like rasoi or oil is not registrable. Happy nappy for this children this diaper etc. was objective like this. The point is they should not describe the article themselves. So it's not objective. Some trademarks by virtue of long use but mismanagement, that is, they have not been renewed from time to time. They lose their registration rights and they become redundant. Aspirin, Xerox, Thermos, Cornflake, Walkman, they were very, very famous trademark some time back, but they are not renewed it. Now, anybody can go to medical shop, ask for aspirin, Xerox. We do not know that they are registered trademark, but now nobody is objecting, like the Thermos, Cornflake, Walkman, etc. Similarly, along with trademark, there is sometimes a slogan also associated. For example, think different or think outside the box. Always you find along with Apple computers. Because I am worthy, you will find L'Oreal products which will attract the lady. Just do it with Nike. And other examples are McDonald's, I am loving it. Amul, the taste of India, Thumbs Up, taste the thunder, Fruity, Station, all these are the slogans or whatever taglines. These are registered along with the basic products or house marks. So McDonald's shown here. So they, along with the protection of the logo or word mark, this tagline is also protected. By virtue of their use, there are certain types of trademark, like, and you know about that because you know Woolmark, you know ISO certified marks, etc. These are given by the proprietor of these goods or organization with members who comply with the standards. This as mark also. Collective mark is owned by association, members of the association, and they are authorized persons of who are members of the association. For example, Noga, NACO, Orange Because Association, C Association, there can be Indian Medical Association, all these. So these are called a collective mark. Packaging can be very good trademarks. For example, packing of Cadbury, Colgate, Stability, etc. This packaging, you are immediately that product comes to in mind. The image is great. So this is a powerful packaging, the powerful mark. It's a powerful packaging, powerful mark because it identifies the product and the manufacturer simultaneously and immediately. Sound mark, I said to you, for sound mark you cannot see. Therefore, format of 30 seconds being recorded on a medium or that sound recording is the true. Word mark is like 20th century also. Yahoo, Blink, mobile phone, etc. In addition to this, there are well-known marks, and which you are quite aware because you are using this branded shirts, Godrej, Bisleri, Coca-Cola. These are well-known marks. 7 o'clock razor, Gillette, So they have become well known because substantial segment of people know about this, they use it, and there is a commercial value because of the reputation, quality, reliability attached to those products, and they are registered well-known trademark so that any authorized use in any class of the article, because like design, trademark is also class-based registration. So design, the trademark registered for one class can be registered in another class provided there is no parallel between the products and it is not registered in that other classes. But in case of well-known marks, it is not allowed. So this is solely protected by all classes. So therefore, Gillette 7 o'clock was not allowed to be registered as 7 o'clock toothbrushes like this. Then there is a combination of colors also, because of combination of colors, or purple color packaging Cadbury or Pepsi, red logo or red color of bottle of water, etc. These have, because they have, this symbolizes, embodiments the product. So combination of colors can also become a very good trademark. What are the benefits of trademark? That is attached, attract customers and create image of product in the minds of people. As I said, substantial value of product is due to your trademark, because any firm, any enterprise, when it is accession is made by some other firm, the reputation of the brand in the market is always very important. So if Big Bazaar is taken by, say, so the value of Big Bazaar, if there is no
So your voice is breaking.
Okay. Yeah. So the value of the, now is it clear? Hello?
Yes, sir.
Okay. Now substantial value of the product trademark, so that what we call brand value. So the goodwill earned by the product in the market is protected, and in due course of time it becomes the asset of the product company, and brand value is developed. So when the company or enterprise or any product is sold or accessed by other person, the brand value of the trademark is always there, substantial value. So because of brand value, consumers make repeat purchase. When your friend wears some branded shirt, he likes it, you will also go in for that purchase, and your friend also will purchase that. So repeat purchase is a very good quality of trademarks. Then some few trademarks communicate very effectively with the public purchasers, and some trademarks can stand out in the crowded market, for example, Apple. So these are the benefit. So also your number, there may be of the laptops and other mobile data. Apple stands on its own as a singular important product, and trademark stays forever. That is, it can be renewed periodically, what I said to you. So these are some examples where the economically efficient communication can be made as soon as you see at this brand, you immediately recognize the value and differential purchase made. However, the duplicating or copying authority the popular trademark is a crime, punishable crime, both fines as well as imprisonment when it is proved. That's why Nike and Hike, Distillery and Missouri, Ole and Ole were not allowed like this, and they were rejected, and maybe some punishment also given. So this was about the trademark. Basic, you have to apply to trademark registry of your zone for trademark registration, giving the representation as to how is your trademark, word, color combination, how to claim, etc. The seat representative seat like designs, and nowadays it is given very fast. Your examination report as to whether it is registrable or not comes within a month, etc. So trademark registry is functioning very fast, and once it is registered in your name, you have to pay the renewal fee, and it can be renewed thereafter. If there is a opposition, then you have to pay that also. That is not to be you have to fight it. Now we come to copyright. Copyright again is a different. So we have seen patent to some extent, design and trademark. So these are given for different aspects. So copyright is the separate right, and it is exclusive right for original work. Now this original work can be literary, dramatic, musical, artistic work, cinema, film, and sound recording also in this category. What does original means? As it were, the original means the work must not be copied from another work, but it was substantial copy, and it should originate from the author himself. Right? So third party cannot apply for this purpose. Copyright comes into existence as soon as the work is created, no matter it is good or bad, etc. So any work, for example, you take the photograph Taj Mahal along with other friends also. The photograph is your copyright. Whether you register or not, that does not matter. Copyright comes as a bundle of rights. For example, any work is created, the other above category, right? It can be reproduced, it can be communicated, it can be adapted, it can be translated. Each activity has its own right, given by the Copyright Office. So each right can be independent of each other. For example, if novel is published, then publisher's right, serialize in TV serials, newspaper, magazine, or it can be licensed for film also. So each right is different and can be exercised independently. Copyright is not protecting titles, names, slogans, etc. And copyright is not given just for idea, because the material form to which ideas are translated or manifested is given the copyright. Therefore, the person who has closed the idea in certain form gets the copyright. So author has no monopoly in idea. Others can produce the same results. So whatever you have to produce, that is only your copyright. On the same idea, people can work and get different rights also. And there is no copyright for a person who merely communicates a brilliant idea to artist. So again, true. This is true for other form of ideas also. For copyright, when somebody gives you idea as to how novel should be done, etc., there is no copyright. So copyright is vesting only in the work which has been created. Duration is quite large for copyright. For example, original and depends on the nature of work. Original literary, dramatic, musical, and artistic work for this, the lifetime of the author, 60 years from the year following the date of author. Cinema, film, sound recording, photographs, work of government, 60 years from the year following the date of publications. Broadcasts, reproduction rights, special right in respect of broadcast for 25 years. Performance right is for 50 years from the date of performance. So these are the various traditions available as rights under copyright for different types of works. There is a fair use concept. What we have seen that any infringement of the copyright by way of authorized adaptation of copy is a crime. But there are the exceptions for this in the form of fair use available in the Copyright Act. So copyright generally, when substantial part is made use of, then it is copy. But the owner of copyright can prevent such unauthorized copy by taking appropriate action. So the fair use are exception to this, for which infringement action cannot be taken, and this includes, and these are permitted without specific permission. You need not take from the copyright owners. And this work includes the use for research, study, criticism, review, and news reporting. You can use for quotation of a portion from the copyrighted work. You can use the copyrighted work in library or schools and in the legislatures. It can be used in connection with judicial proceedings and translating or reproducing small quantity for use of teachers and researchers. As I said, copyright is not for the idea itself. So idea suppose in the classroom, teacher gives the idea that how dog will play with the ball. This is the idea. Different pictures can be painted on this. As shown here, the dog can just think of his thinking as to how I'm going to play with the ball. Other is shown in the human format and is joyfully playing with the ball. And in third, the dog is just fantasizing and thinking as to how can I play with the ball. All these are different manufacturing of same idea, so there are different copyrights. The last is geography indications. It is given as we have said for agricultural products which are reviewed because of the territory. Owners, who is the owner? So patent, design, trademark, and copyright is can be owned by individual as well as the companies. However, geography indication is such right which can be owned only by association, not by individual. Association of persons, producer, organization, etc. Established or reprinting under the law, which is called registered proprietor or GPR, held by community for 10 years and thereafter renewable every 10 years. Because it is community right, there is no assignment possible, transmission possible, licensing or mortgaging because it's a public property. And it promotes economic prosperity of producer because the goods which are registered as GI, they become instantly famous and they can get all the value to the product. So, the examples are Darjeeling tea, Nagpur oranges. Then this is Mysore sandal, soap and oil. This is special mineral made of metal in Kerala. This is Arnamula Kannadi. And then this is LFK point. There are about 400 plus GI registered by GI registry, which is at Chennai. Trademark offices are at 5 places and GI registry at Chennai. A register and application is made giving all details of the product, specialty of the product and area, location, etc. map and the specific properties of the product, etc. to GI registry. It examines the application and grants GI rights. So this is Kanchipuram silk, this is your Ulu shawl, which have been registered. Some of the famous GI given by GI registry, like about hundreds are there. And the Coimbatore weight grinder is a very famous GI for manufactured items like this. So this is regarding the IPR. This is regarding IPRs, the design, trademark, copyright, and GI what we are seeing. Now we intend to study in more detail patent rights, which is subject matter of this talk also. So we start now patents. As we have said, patents are given for inventions, which are quite often technical solution to a technical problem. They are granted to inventor. Or if inventor is not willing, then he can assign the right to third party. So it can be granted to inventor or assignee. So this is a patent right, exclusive monopoly right, because government is granting you the right which excludes others from making, using, selling, or importing their product or using their process for a term of 20 years from the filing. The use right, the territorial right valid in India, but you can get this right in a foreign country also by adopting special procedure, that is patent cooperation treaty procedure or convention. So this right which is granted, monopoly right, then in view of that, what you are giving the government? You are giving to government, that is, you are disclosing your invention in full. It can be used by any third party for development of his own invention. So you are disseminating the knowledge and invention in the public domain or public use. This is what you do. What government gives you of that is a patent. So this right is like any other right. It can be shared, licensed, or sold, and it allows to initiate legal procedure because it is the right is given under the law of the Patent Act passed by Parliament. So it entails you take any legal action against the infringers. Of course, this is not absolute right, and public interest has always been taken care by the patent rights for the nations. So there are some provisions for the public sector. Now, what are the benefits of patent rights? What we have said, the benefits of designs, trademark, copyright, etc. So benefits of patent rights. You can once you get a patent, you can exploit the right without fear of copy or limitations or unauthorized. During the term of patent, you can have sleep, you can rest peacefully under the patent protection G. Patents are open for free use once patent term expires, after 50 years, or if you fail to pay renewal fee, then it can be used by all. G. So if patent is granted today, and after 2 years, no renewal fee is paid, and it is extended time also doesn't pay any renewal fee, the technology can be exploited commercially, otherwise whatever is possible. Then it avoids duplication of research. It's very important because as a rule, all patent applications and after grant of patent, they are published in the e-journal of patent office. So they are very much in public domain. So when you want to start your work, you can refer to them and avoid duplication of research. And this patent specification, for example, 58 or 60,000 are filed every year, and worldwide billions of patent applications filed, and they are the number is going up by billions every year. So these are the inventions disclosed for the first time to the world. So this is virgin knowledge, and the published patent specification, which is mandatory, thus forms an ocean of scientific knowledge and technology, which is available to you with the click of the mouse, because most of the patent literature as made available by patent office is free to log in. There is no login. So you can search, get information on any patent or database of the world. Patents use valuable guidance for planning for company. Patents is very important tools on success of all major companies. Depends upon how they make use of patents, licensing, etc. When they can plan their R&D, because patent gives the right to exclude others. So when company can plan R&D, they plan how other companies can be kept out of this competition, and they emerge as eminent players in their product. So company can emerge as a preeminent player because that company is the only company having those products or manufacturing those products. Like this. So planning of R&D and forging strategic alliances and identify possible collaborators is another great use, because when you want to say foreign company, Indian company, they will have JVs. Then what are the patent rights held by, say, for example, German company that will be considered, and their value will also be included in the rights. Thus, the patent portfolio measure of company's success. Patent is a tool for international trade. Therefore, it is not surprising that every year thousands of patent applications are filed and granted. Many famous firms, famous companies like IBM, Sony, etc., Amazon, Google, all so many patents are filed and granted to increase the value of them. Having discussed something basic about the patent rights, we now move on technical description and to patent is granted to what? Patent is granted to invention. We have seen what is invention, for which patent is granted, Invention means a new product or process. That is novelty of the product or process. This first kind. Involving invention step is second criteria and capable of interested applications. So these three criteria are to be fulfilled for any invention for which you intend to file patent. Newness, that is novelty, is there when your invention is not part of the state of the knowledge existing on your subject matter previous prior to your filing. What is inventive step? So novelty is not enough because it will be there. So your invention must contain some features, new features, technical features that involves technical advance as compared to the existing knowledge on that subject, or has economic significance, or technical advance and economic significance both. So such features are to be recognized as inventive step. If such features are there, along with if these such features are not obvious to some skill in the art, then your invention is going to be enough to be granted. Obvious to a person's skill in the art means person who knows about the subject matter of the invention, it's the same field, and it has some knowledge regarding the field which is instantly before the controller. And if the such person thinks that I can do very easily this invention, then it is said to be obvious to a person's skill in the art. So inventive step may be denied. But again, obviousness is a subject to matter, and just based upon the matters coming before the patent office. We'll see in detail this novelty in the later part. Then capable of interested applications. Your invention must be capable of interested use. Some use should be there, and you should mention it in the specification. So as regard novelty of the invention, as a scientific student, engineering student, professor, etc., you have so many projects you are doing every year, and so many things can come from out those projects or this. Remember when I was at Nagpur office of this IPO, there was competition among 40 engineering colleges in a KDK college, I suppose, where all projects from have been demonstrated by students of the 40 colleges, and I was one of the judges for that, for selection of best model. I found that out of 40 presentations, at least 10 were such, or 15 were such, that the patent application can be filed for that. They were very, very innovative. I told that there when Professor Handa was there, that can be done, and you can take help of patent office. So then I came back from Mumbai, and I don't know what happened to that. The point is that during the study of engineering subjects, you come across so many new product, new process, or devices which you can think of patenting, provided three criteria are fulfilled. So what is novelty is one of the first criteria of the when there is a prior publication or prior public use, so any. Out of this prior publication, any publication in the format and the patent literature, non-patent literature prior to filing anywhere in the world is one criteria. There should not be public use of a invention in India prior to filing. There should not be prior claiming in India before your filing. That is, somebody should not have applied for patent on the same matter. It is important novelty that it means to be known the public of filing of the applications or of priority. Priority means when foreign applications coming to India, then on that date of the filing or now a little bit more about novelty of inventions, how it is judged, and it is guide to all those potential applicant for patent also. Because reasonable search to be made by the applicant or his agent before you file application, then only you can expect to be successful. Blindly, whatever invention before you file application, it may land in the objection against novelty of the invention. So, it's important to know that one single document is compared for novelty comparison of the subject matter of invention. Mosaicing of element, that is taking multiple documents for comparison, is not allowed only for novelty. And this mosaicing allowed for inventory claim. It's a difference. So checking for inventory claim is more elaborate and detailed than novelty. For novelty, it is sufficient to say that there is no document similar to subject matter. Even if it is there, then it should describe sufficiently disclose and it should describe the invention. If it is not, then it is not valid prior art or prior application for your inventions. Similarly, it should be publicly known and it should be used in public and known to public before filing. So there was famous case when this some good-like cycle was manufactured or patent filing. The inventor brought the cycle to his house, shown to his wife and kid to just to show the kids and wife. Next day or the couple of days, you want to file application. But out of enthusiasm, his mate took the cycle along with the kid in the park. It was seen by many persons. And when the application was filed, it was objected to, stating that it was in public. You should be very careful not to disclose the invention, not to use the invention in public, as well as not to show anybody in the public. Prior art, he kept secret. Similarly, if you do something, some research, and may be similar to what application which is filed for patent, but if you are kept it secret, not in public domain, then that invention, although may be similar to kept secret, is not valid prior art or it is novelty. If the invention is publicly circulated in any document and seen even by one person, it may invalidate the patent. Right? So, if you say there was a case when a pen was invented, it was very good and very good functioning. The inventor gave this pen to his friend or trial and told him that he should not distribute to anybody, but by mistake that pen gave to his friends. Now his first friend was bound by confidentiality and he did not disclose it. Other persons to whom the patent was passed on were not bound by such confidentiality, and so the novelty was lost. We should be very careful in this aspect also. Novelty is not affected when speculative or not entirely accessible or hidden. When in the prior document is cited against novelty of information, it is said that it is it can be done, it is possible, etc. And then it is hidden, not accessible easily, then it is not within novelty. Then it should be, suppose you are in a company or a university and you have made some invention and then you have to submit to authorities who will examine it whether to file patent application or not, because financial consideration is also there. But all these members who will see that are bound by confidentiality and they will not disclose it, and it is not safe that application was in public domain, because all the members who will see this invention as the board members or university members or college members are bound by seal of confidence. But when we maintain secrecy, use for reasonable trial or experiment is permitted. So, if you use the invention for reasonable trial or experiment, it is permitted and now it is not killed. For example, when there was a device, invention for temporary measuring device of a radiator, which is fitted inside the bonnet. To take the trial, that car was run on the road with that instrument there. Somebody knew that instrument is there, or this patent was filed. They objected to following novelty. It was thrown away by the judge, saying that no member of the public had opportunity to go near the car, open the bonnet and see the instrument functioning. It was not used in public, so novelty was made. Prior sale of purchaser, who is due to sell the article to anybody, or if you do the gifts, some purchases will be novelty. I'm talking about this because all inventors, these are the criteria adopted by patent office, but simultaneously, those who want to file patent application also should know that all your actions will give the novelty, so you should avoid them. When any document can be expected as a right of the public, whether paying fee or not, also in novelty. For example, you submit a thesis of your work, project report, etc. work, which is lying with principal or the company authority. With the authority, it is knowledge. The moment it comes on the outside the office or library, there is no knowledge. So before coming to public domain, you should file applications. Another thing and last thing, personal knowledge of the examiner. Our examiners are pretty highly qualified, techniques, etc. They may be knowing more about your questions, but their own knowledge is not giving novelty unless they use some proof. There is some reason for the certain acts are not giving novelty under the act. So there is no anticipation when any application is filed before government bail or any invention is taken forcibly wrongfully obtained by you or from you without your consent, or you communicate your research to the government for defense of investigation purpose, then novelty is not key. Similarly, when you display or exhibit your invention with your own consent or some other person on your behalf in industrial exhibition, which is notified by government and it is published as a consequence thereof, is first action. Second action, your research paper is read by the inventor about on the invention and published before the authority and published thereafter. Second condition. Third, or if it is prior publicly work in India only for reasonable trial as we have said, without compromising secrecy. So any of the action ABC will not destroy novelty if patent application is filed within 1 year of any of such steps. Now we come to inventive step. So inventive step is there when there is a difference. The novelty is there, but this difference or novelty or difference between the prior art and invention is substantial and significant because prior art as a whole is considered and combination of publications is also allowed. So there is no inventive step when invention provide just juxtapositions of known devices or processes, not producing any non-obvious working relationship. Claim compositions, known ingredients is likely to obvious unless there is a synergistic effect for mixing of these compositions components, which we call value addition. Unless it is just not patentable. So there is no inventive step when invention lies only providing equivalence. For example, mechanical, electrical or chemical equivalence. No norm. For example, use of hydraulic motor instead of electric motor simply in the problem. Similarly, there is no inventive step invention is building structure made and prior publication is there, prior art is there. That structure of lightweight material but does not mention aluminum. Then anybody can persons can be confused that this lightweight material will contain aluminum and he can, so invention is lacking in inventive step. However, there is an inventive step when the particular case, there was a drug where A and B were components and A was somewhat hydrophilic, same by was only in the somebody treated material A inside layers of B in the tablet form, so the shell pipe increased enormously and therefore patent was this innovation was legal patent. Therefore, your technical advancement, how you bring it, which is not obvious to persons in that is important for determining the inventive step. Inventions are not taking. There are most of inventions which are by virtue of repeating the requirement. There are certain categories of inventions or cannot be granted in the C and section of the patent. So you should study before filing of patent application whether your invention is in the area of the category. this study section 3A to section 3B. For example, invention which is pseudodas. This is anything obviously already and the law. The personal exploitation should not be contrary to public order or morality, or which causes serious prejudice of human, animal, or plant life and health, or to the environment. What does it mean? For example, this is gambling. It is against the public order. It's cannot patented. A device for house breaking. The process of cloning human beings or animals is against the public morality. So this invention of say process of cleaning water in the lake, but at the same time it is killing flora and fauna. So these are creating serious prejudice to life. Such inventions are not patentable. Discoveries are not patentable. The discovery of scientific principle or discovery of any living thing or discovery of non-living substance occurring in nature, because there is no human contribution for that matter to exist, because it is a gift from the mother earth or nature. They are existing and there is no your contribution, so there is no patent for that also. Similarly, there is no patent for abstract theory and say non-living substance like mineral, etc. So thus, Archimedes principle of superconductive phenomena are not patentable. However, and as science student, you know that many apparatus devices can be manufactured based on scientific principle, the Archimedes principle, or that is heat treatment or like gas, superconductive phenomena. All this, there are so many instruments, appliances, or big processes are based on these principles. Then all these are patentable. So this is related to chemical invention where already some substance is known, then new form of that substance or the known use, and the such use does not enhance the known efficacy of that substance, then there is no patent for it. For example, if there is aspirin and there is a new use of new use, that is, for example, handling say headache or say cardiology, no patent for it. Then if different form you are claiming that is giving some benefit, unless just such benefit of the new form of the known substance give you more efficacy, then also there is no patent. For claiming any known process or machine apparatus, you should remember that such known process should result in a new product or should employ at least one new reactor. The inventions which are not patentable also include this is admixtures. Suppose you mix component A and B, and they show separately their properties in the mixture as well. This is mere admixture, and there is or aggregation of properties, and there is no patent for that. For example, it is antibiotic analgesic, a drug and drug combined with these two, A and B, which is antibiotic and analgesic, without any synergistic value addition, no patent. However, soap, detergent, lubricant, etc., because their components are different and their end properties are different, so they show value addition. They are synergistic mixtures, so there is patent. This particular thing, that is mere arrangement or rearrangement of replication of known devices, is functioning independently of another is a known way. So each word is important. For engineering device, when you are allowed to arrange or rearrange different components, if they are known devices and that is way to working on them, and they are working a known way, then obviously that cannot be better. So, the example for this, methods of agriculture and horticulture normally are not better to save the rights of farmers. So, cultivation of plants, essential biological process, and preparation of improved soil, etc., may not be patentable, but all agricultural equipments are patentable. So, when we say that certain things are not patentable by virtue what's your exclusions under this section 3. It should be remembered that all others which are not containing section 3, section 3A to section 3, other things may be patentable. So this is a very small subsection of the invention. This is not patentable. So you should think positively that this is not patentable means everything is not patentable. Doesn't mean it does not mean like that. So all host of the invention is all outside this particular category are patentable. This is very clear from the scope of patentability in horticulture or horticulture. In horticulture, herbal medicines or cosmetics, several patents are available. Perfumes, oil, syrup, for example, rose syrup, essences, flavoring agent made from flowers or say herbals, and these can be used in foods also. Animal waste or plant waste material, substances made from that. Compositions for insecticides, pesticides, for example, neem-based, fruit-based products and processes, for example, drink, jam, pickles, conditioning of fruits and texture, etc. Products from fruit waste like kernels, seeds, etc. And like examples are polymers, heat-resistant resins, varnishes, ultrafine silicon carbide powder from cashew nut seed, mango kernel for composition or confection. These are few examples. And these products have been made from the fruit waste or herbal waste. So the point is that there are so many patents, most of patents available in the excluded categories also. So don't think negatively, and think always positively, and check that your invention does not fall only in this particular section, but otherwise is patentable, you have to say, right? Next is the doctor's knowledge is not patentable. The medicine certificate to process diagnostic as applied by a doctor is not patentable. Another is treatment of human beings and similar treatment to animals also. For example, the processes for removal of cancer tumor, removal of dental plaque, diagnostic methods, prophylactic methods, for example, methods of vaccination, blood transfusion, these are the doctor's knowledge. These are not patentable. The processes under medical treatment and doctor knowledge also. However, all the appliances, medical devices, biomedical devices, scientific devices, right from to X-ray machine, all are patentable. Plants and animals in whole or part thereof are not patentable, and macroorganisms is patentable only if it is genetically modified and used to produce certain useful product, useful novelty, and as a category of patentability. Seeds varieties are not patentable, and essential biological processes are not patentable. Now we come to important subsection of section 3, that is 3K, which deals with the mathematical method, business method, algorithms, or computer program per se. As stated in section 3K, these are not patentable. Particularly of importance and interest is computer program per se. There has been debate over the years on this issue. That is, per se means by itself or as such. So when computer program is as such used and a patent application is made, then it is not patentable. But using as say, per se means it shows that you are referring to something on its own rather than in connection with other thing. So per se allows you to not to include other things which are combined with computer program by definition. You should read this per se definition from this angle, that any other connection with the computer program per se does not fall within the exclusions under section 3K. So computer program claimed by itself as a record on carrier may not be patentable, but program control machines or program control process is normally patentable, and any new calculating machine may be patentable. In this case, guidelines in 2017, because there was a demand from the industry to verify what is the exact scope of exclusions under this section 3K. So certain things have been made clear, that is computer program per se are clearly not patentable. So the storage medium having instructions basis, computer memory with instructions stored in the computer-driven medium is not patentable, obviously. The claims of computer-related instances are so. In second aspect, we will find that the computer program is often expressed in terms of means, that is, means for converting digital to analog signal like that. Such means, which are used to express computer software, if they are associated with some physical construction features, and they can be considered for patentability, and if there are no construction or structure pieces available, the execution of computer program will not be allowed. If performing the invention solely by computer program is possible, certain invention is possible simply by using computer program, then such thing is also explored.
Thank you,
Okay.
sir.
Okay, no. I'm not finished.
Thank you, sir, for giving us your valuable time. Okay, sir. Please continue.
This
Sir.
is, I have not ended my presentation.
Ma'am, I think sir has not finished. So he'll be continuing for some more time.
So mathematical method is not patentable. Business method is also not patentable unless it refers to some apparatus, etc., some technical process, etc. Then it can also be considered an algorithm clearly not patentable. So the High Court has clarified the scope of patentability in computer science. So court has held that computer-related inventions demonstrating technical effect or technical contribution can be patentable, even though it may be based on computer program. There is no patenting in respect of computer program per se, and not all inventions based on computer program can be said as not patentable. And the effect that such programs produce indulging in digital or electronic products is crucial to determining test of patentability. And patent application in this field, you have to examine to see if this will result in a technical contribution. So now, because of the judgment in the High Court and guideline issued by the Patent Office, now increase the scope of patentability in computer science. For example, here I am showing a glimpse of best inventions of 2017 that by IBM company or garment optimizations, and then Indian inventors also there. And gist of the invention is the IBM acquired the patent to form smartware that could adopt itself for optimum comfort. The proposed textiles could have intelligible applications, right? The patented fabric features a set of sensors and inbuilt computing device. This device will analyze our data on the heart rate of the wearer to external weather conditions and configure the optimum comfort conditions to allow the garment to become warm in cold water and vice versa. For example, the fabric may adjust the shape, texture, and density of threads to create comfort for the wearer in summer, allowing the garment to show the skin to perspire and transmit moisture. And in winter, the fabric may change configuration, the threads protect the wearer from the cold. So this variable futuristic comfort wear, the clothes that adapt to you surrounding was adjust the best invention, and it was for computer science. Now, next, non-patent inventions are a matter of copyright protection, like literary, dramatic, etc., or mental act, game, etc. And this one, this presenter information or topography integrated circuits, and last generation knowledge is really important because they have been very useful inventions which have been granted patent, or the just synergistic value-added product knowledge like wine from roses or wine from banana flowers or rose or soup, ready mix soup, etc. Because the patents not there for the traditional knowledge per se or aggregation valuation knowledge or duplication, but any value addition can be given patent. And lastly, section 4 says innovations to atomic energy falling within certain categories of atomic energy is not patentable. Now, I will briefly go in for a couple of minutes for process of patenting, and then that is there. Let me check. So with this, So you have to make applications for patent applications. I just summarize the process here. So for any filing of patent applications by student, professor, anybody, but there is no age bar, there is no qualification requirement. Individual can file, number of individuals can join together, or individual or company can file application within the jurisdiction as per your say western, south, or east or west zone. We call it western zone, that is office at Mumbai. So you have to think of inventions, or conceivable inventions. You can file with provisional applications. What is that? Because if you are doing some work on that, obviously you are taking care of that. I will fulfill the criteria of patentability. Then you can file with provisional applications, and then you can file complete specification. What is the difference? Because when you file patent application, you are claiming some patent right, and this can be claimed on the claimed part, the legal part, and description at the provisional or complete specification is a description part. So you have to write as per the procedure laid down, which is available in our patent manual, which is given in the website. So there is we will not dwell upon how application for the drafter, etc. But complete specification must have claims. Provisional specification did not have claims. Provisional specification, you should write inventions in the running format and to what extent is complete and what you are going to do. Whereas complete specification should write complete inventions, all experimentations, best method, how it is going to work, and claims. That is what you want to claim as a right, which is valid and can be enforced to law. So if you file provisional that your work is not yet complete, then you have 12 months to file complete specification. If you fail to do that, your application will be abandoned. Now you file either direct complete specification or provisional specification in the application along with fees and certain forms. Then this application is treated as a valid application for grant of patent. It is published in the pen of the journals in 18 months. And you can file, you have to file request for examination on this application, filed with complete specification. And after publication, it is examined by the patent office for fulfilling the criteria of novelty, inventive event in such application in a way which you have seen earlier, right? So it is for that purpose that your application should be examined. You have to file request for examination 48 months from the date of filing. And then examination, first examination report, that is whether there are any objections to this grant of patent based on the criteria which you have mentioned. It does not have novelty or inventive step or does not have industry application. All these objections are, if they are there, raised by patent office and they are communicated to the applicant as a first examination report. And satisfactory replies have to be provided by the applicant within 6 months. Period extended for 9 months. Now, if you fulfill the objection, patent will be granted to you. If you don't fulfill and partially fulfill, then you will be heard. Controller of patent office will be giving a hearing, and hearing will be conducted wherever you again get a chance to comply with the requirements within certain period. And if you fulfill these objections, then patent will be granted by the controller. If you don't fulfill the objections even after hearing also, your application will be abandoned. So there are two abandonment before filing. So after filing or before examination, after examination, after non-fulfilling the objections. So the patent is granted, it is then open for post-grant applications. Of course, before grant of patent, anybody can file the objections in the form of pre-grant oppositions, and this is open for pre-grant oppositions by anybody that patent should not be granted for this. Now, as I said, it takes around little bit reasonable time to grant a patent. So, the Government of India has introduced the process of examination, expertise examinations that for certain categories of applicants, for startups and natural persons, and then SMEs, female applicant, no, not natural person. So the fees for natural person, startup, and then MSME is minimum. That is 80% of the fees required for big entity. This is one concession. In key concession at all stages. Now, these applications filed by startups or say person who has filed international applications, or MSME, or female, or government companies, etc. They are eligible to get their application examined express without falling in long queue. So these are been provided by Amendment of Patent Rules, where you can expect a patent within 1 year or after filing request for grant. Otherwise, it may take few years, 3 years, 4 years, right? So this is a provision made available for expertise examination for categories which I mentioned just now. Similar as is for trademark application also. Another thing which I want to mention here, and which is a common thinking among the people, that you need to file only for big inventions. So 95% inventions for incremental inventions. So any product you go on improving by even incremental improvement, then there may be patent for that. For example, in ballpoint, data is old, but there are patent, hundreds of patents for ballpoint, pen, ink, pen refill, pen body, smooth writing. Actually, these have been patent granted and high, right? So in the end, because time is coming to it, I will word of advice to applicant or patent who may be willing to file patent applications by virtue of the research, that when you have undertaken the work with the view to complete R&D, useful R&D to file patent, then you consult before patent literature and non-patent literature as to what the work has been done on your subject matter to avoid reinventing the wheel, which are shown. And also get some information on patenting process also through awareness programs or study. If you not confident that you can file a patent application, consult the patent professional for that purpose, but don't file wrong patent application, which is of no use, because you cannot achieve the rights by wrongly filing patent applications. We should avoid prior publication before filing, prior sale or use of product before filing, and avoid giving lectures or presentation filing of patent application. Okay, all these actions will kill your novelty. You can seek professional advice also secretly. And once your application is reasonably complete, do not delay in filing the patent application. It may deny right to you, because simultaneously many people may be working on the same problem and they may forestall you, because they may be first invented. In that case, they may file prior to you. So as soon as your work is reasonably complete, file the patent application, right? And when you work together, the lab or student professor or group of students, etc., verify the rights to each individual, what can be right of that. For example, when you are guided by professor has no right as payment for the patent right. He can be co-applicant. The basic right is of student who can file patent application. And if student is not allowed to file patent application, that amounts to wrongfully obtained. Right? That pre-research service is important, because it is assessed that 25% of all R&D efforts are wasted each year are already invented inventions, so you cannot do about anything about that, right? So the case of delayed filing is very clear, very classic example I am giving here. Telephone. You all know that Graham Bell was inventor of telephone, right? But other inventor, Elisha Gray, made same invention simultaneously. But Alexander Graham Bell happened to find first in 1876, and Elisha filed a few hours later. She was denied patent right. So prior filing without delaying is very important. Similarly, don't be afraid of my subject matter is fall in public domain, publicly known invention, because it is not right. Technology is very fast today, and don't be afraid of making applications, even if it is slightest improvement in your applications. I think with this I should stop here. It's already consumed my time, and then I will welcome any questions if they are there. Thank you. Yes. Hello.
Thank you, sir.
If I can take questions if they are there. If they are there. There are no.
This is one of